Thank you so much for watching Law School Made Easy at Law School Made Easy 256. I want to straight go to criminal law. We want to discuss how are we supposed to go about criminal law. And we kindly ask you to subscribe, share, and keep liking our videos and keep the comments coming through. Colleagues, if you want to be maybe a member, that you get these videos instantly, still you can click on join, the button of join down there, and then you can become a member, and then you just have to pay 10,000 only, and then the videos will be coming to you. Every time we post a video, you get it fast. You get the video fast. You have those benefits. So now we want to go straight to criminal law. Colleagues, this is the widest semester in terms of criminal law, and when you're discussing these offenses, you must be clear. But the only thing we need to know, every offense you're going to discuss, colleagues, has elements that makes up the offense. In first year, first semester, you discuss something we call the burden of proof. And we all said that the burden of proof lies on prosecution to prove beyond reasonable doubt. Now we are applying these principles. Now we have the offense. For example, the offense of murder. Now, the offense of murder, for it to stand, it has elements that the prosecution should prove. Remember, you said that if prosecution fails to prove beyond reasonable doubt, the accused is acquitted. But if the prosecution proves beyond reasonable doubt, then the accused is convicted. So we are saying, this semester, you must be able to discuss all the offenses and their elements. Let's talk about murder, for example. When you have a case of murder, you prove 4 points. 1, there was a dead body, the unlawful act, malice aforethought, and then finally, the participation of the accused. Now, you must, at every element, put at least 2 cases. You can have a case, it is okay. But at every element, you put a case. If you say there must be a dead body, Uganda versus Namwanje, you explain the principle of a dead body. That for murder to occur, there should be a dead body. In absence of the dead body, then, and absence of circumstantial evidence, then murder is likely not to occur, because there was no. If you are claiming somebody was killed, then prove. So that is what they expect of you. All the elements. But colleagues, malice aforethought has a full section in the Penal Code Act, related starting from there. But again, when a question requires you to discuss murder, colleagues, you are expected to begin with Article 22 of the Constitution that preserves life. Nobody should take away the life of another. Only when it can be taken away, only when we are handling what we call a court sentence. That is one area. 2, you now go to define murder as per the section in the Penal Code Act. And after you have defined murder, you now start to discuss element per element per element per element. And then you put a case. Colleagues, never discuss murder and you run away manners telling us the limitation of murder. That when somebody dies between 1 year and 1 day, then it is me who caused the death. But after that, I have not caused the death. You must talk about it down there. You must talk about causation. In a paragraph or 2, a person is deemed to have caused the death of another. You discuss something about causation. That is, even if it has not been asked, that is when you have a complete set of murder discussed. Then we can cross down to rape. Colleagues, you must discuss rape. And on every element of rape, you put a case. The section is clear. When somebody have unlawful carnal knowledge without the consent, okay, without the consent, even if you have the consent, but obtained through false representation, and for a case of a married woman, you impersonate their husband, all those bits, you put a case. You put a case. That's when you are able to exhaustively discuss the term rape. Colleagues, for every question in criminal law, the minimum you should write is 10 cases, I repeat. If you have 10 cases, then you are good to go. You are likely to highly pass. So read as many cases as you can. Colleagues, let's read as many cases as we can. Then we can go to another first, defilement. Defilement. We're going to discuss defilement. Section 116 of the Penal Code. You must write the whole of it. Because if you look at it closely, clause 1 of, subsection 1 of 116 defilement discusses what we call simple defilement. Then 2 tells you about attempted defilement. We can't discuss attempt, we covered it last semester in equal weight offenses. Then clause 3 tells you of aggravated, but they give you the elements in clause 4. Which clause 4 you have senior offender, if the victim is disabled, person in authority, guardian, HIV, a girl below the age of 14. That's aggravated defilement. Then clause 5 and 6 and 7, they are explaining what we mean by sexual act, what we mean by senior offender. A senior offender, colleagues, to reaffirm it, is someone who has previously been charged of the offenses of murder, defilement or aggravated defilement. That's what you call a senior offender. Now, and then you give a case, but for murder to occur, you must prove all the elements. But for defilement, if the accused has AIDS, business closed. You don't need to prove the others. If the victim is below the age of 14, business closed. Aggravated defilement has occurred. Okay? If it's a senior offender, business closed. If it's personal authority, business closed. And then you give all those cases, Pasco Dimba, and very many other cases. But for everything you discuss, the cases, defilement, 10 cases. Then let's go to robbery and aggravated robbery. Colleagues, robbery happens if you take something from colleague by use of force, anything you do, but for as long as you deprive them of the right to own a property. So when discussing theft and robbery, you begin with Article 26 that says everyone has a right to own property. You don't deprive. And then aggravated robbery, colleagues, you now bring in a weapon. The moment there is a weapon, that is aggravated robbery. Robbery use force, but no weapon. You threaten, force, no weapon. But in aggravated robbery, there is a weapon. So you give the cases, Uganda versus Mama Sebufu, and very many other cases. But note, what differentiates robbery from aggravated robbery is weapon. Now, some of you have a tendency to say that theft, you begin discussing robbery by discussing theft because you feel all the elements of theft and robbery. They know. The examiners know. Just discuss robbery. Forget about theft. Then where there is theft still, Article 26 is what opens your statements, and then you tell us about theft, the ingredients of theft. Now, theft is very tricky. It's a bit wide, colleagues. Now, when it comes to theft, look carefully. Look at the question, if the problem question, and identify which elements of theft they have brought. Have they brought value, conversion? You identify. If it is value, you know that. You discuss the case of Shewarula. Conversion, Ara versus Tana. Very many cases. You begin to choose. Look at it. Appreciate the elements of every offense, colleagues. Let's go to housebreaking and burglary. Housebreaking happens during day. Burglary at night. Same elements. What differentiates them is night. Colleagues, know the hours clock. Like me watch here. Know when do we start the night, when do we start the day. I also don't know. But you who is going to the exam know. They'll give you a time when the heist happened, but you can't tell whether it was day or night. So colleagues, do the study of the clock when it comes to burglary and housebreaking. But they describe for you what amounts to entering. Colleagues, housebreaking and burglary happens by entering. Now, entering means that even when you put something in the window, you have entered. Any part of your body, even if it is a finger, if you steal somebody's phone from the window, you pull it, and then you use your stick to get the phone, you have entered. That is housebreaking. Anything. So, be clear. They'll tell you he was out and he put a stick, and then you say, there's no housebreaking. They never broke. No? Entering. And now we can give an example of the case of Masenu Butiti. Masenu was found breaking the garage, and he was caught, but he never entered. So they were charging him for housebreaking. Court said no, he never entered. He was found breaking. So you should have convicted him under malicious damage, that he had caused the malicious damage. So be very careful, and then read the very many cases are in there. So let's go to grievous bodily harm. Colleagues, grievous bodily harm. You cause a permanent injury. A permanent injury to somebody. Uganda versus Pampala. A permanent injury. You disfigure, you maim somebody. That's what you call by causing grievous bodily harm. And then we have the common assault and unlawful winning. Colleagues, pay attention to the differences in between these three. The other one is temporal, the other one is permanent. So, then I also urge you to read the Anti-Homosexuality Act, because it's likely to be asked. It's very small, about 17 sections. Appreciate it. We have no cases because the law has just been made. You know that the law does not act retrospective. When discussing it, you must still say that we have many cases, but the law does not work retrospectively. The law does not go backward. So we do not have so many cases, but you must be able to explain the principles in the act that make up the offense of anti-homosexuality. Then treason and terrorism. Colleagues, terrorism you should address yourself to all the acts, all the amendments which have come up. And then treason, the one thing I can tell you about treason is there are very many cases, but Article 3 of the Constitution, and then treason in the Penal Code Act, whichever penalty in there is death. Treason, all the penalty is death. Treason, if I sit in a meeting and I don't participate, you cannot convict me. You should show that this person participated. They'll give you problem questions where they are telling you that Walter was in that meeting, but he said nothing. But because you see others are charged, you also want to charge me. You must prove that I said something related to overthrowing the government, killing the president, doing what, in all those circumstances. So, the take home here is, let us read the cases, 10 cases per number, move out of that criminal law paper when you have written 50 cases. That way, you'll be able to get an A. Then there are those other offenses: perjury, corruption, embezzlement, false pretense. Read them because they may come in short notice. Some of them come in short notice. Perjury, embezzlement, false pretense, administrative something. There are very many other offenses. So, but do not come to enter this paper when you have not appreciated the concept of murder, rape, defilement, treason, terrorism, Anti-Homosexuality Act, common assault, unlawful wounding, grievous bodily harm, theft, housebreaking, and burglary. At least come when those ones, you know them very well. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. We ask you to subscribe, to share, and like our videos. Until next time, Yunus here has been on camera. See you next time. Thank you so much. Have a blessed